Hi, I'm Will Ha of William Ha Law. I do wills, trusts, and I help people avoid probate. And I believe estate planning is for everyone. In today's episode, we're going to talk about the most commonly asked question I get whenever I talk about estate planning, and that is, what's the difference between a will and a trust? When I get this question, I probably spent way too much time getting right into the weeds, talking about trustees, beneficiaries, and then I quickly realized that I've confused and overwhelmed the person who asked me the question. So now I just dive right into the concept of probate, what it is, why you may want to avoid it, and then work backwards from there. So the general rule is this: if you have to take away one thing from this entire video, it's this. The general rule is if you die with assets owned in your own personal name, people who want those assets transferred over to them, be it your children or a friend or a charity, they have to go through probate to get it. So probate is a court proceeding where the goal is to appoint someone to represent the estate, settle claims by any creditors, if any, and then distribute what's left over to heirs or beneficiaries. In probate, the document that's the star of the show is the will. A will generally have three main things that it does. Number one is it specifies who the personal representative should be. Number two, it would nominate for the guardians of minor children, if there are minor children. And lastly, it's to specify the beneficiaries, who gets what and how much. If there's no will at all, then the government will apply the default rules, and those default rules for who gets what and how much and who can be nominated as your personal representative is called the rules of intestacy. So a personal representative is somebody who essentially tries to help marshal and move the probate process forward. They represent the estate. They might be a parent or a child or a friend. They help with paying down debt and they help with administering the rest of the estate. A nomination of guardianship is a way for you to nominate people to come in to become guardians for your minor children, to have the same legal rights as they would if they were their parents. And lastly, in terms of who gets what and how much, this is fairly straightforward, and this is what people commonly think of when they think about wills in general. So that's what a will is. A will is used to override the default rules in the court proceeding of probate. A trust, on the other hand, is a legal instrument, and it's an agreement between different people who will manage assets while you're still alive, and it has provisions for the management of the assets beyond your death. Normally, when you create a trust, you're the person who've created it, and you're also the trustee, and you're also the beneficiary. You've basically created a legal instrument where you have the full control of your assets throughout your life. There are provisions in a trust for somebody else to come in to manage those assets once you are gone, and that person is called a successor trustee. So, how does having a trust help people avoid probate? It does so because once you've created a trust, because it's a legal entity, you can transfer the assets that you own personally in your personal name into the trust. And because you no longer own those assets in your own personal name, probate is not necessary to transfer it out to someone else upon your death. So one of the key differences when it comes to the administration of an estate through a will or through a trust is the cost. When you have a will and you go through the probate process, you're essentially relying on the probate court to provide authority to transfer these assets, and there are quite a few costs associated with it. So number one is the petition cost, which is a court filing fee of $465 for the opening and closing of the case, and this is in LA County. There's also publication costs. It's the cost to hire newspapers to publicize the fact that the probate has been opened. Number 3, you may have to pay a probate referee. And lastly, you are by law required to pay the personal representative. And if the personal representative happens to hire a lawyer as well, you have to pay them too. And by the book, it's essentially as follows. It's 4% of the first $100,000, 3% of the next $100,000, 2% of the next $800,000, and 1% of the next $9 million. So to put things in context, if you had a home that was worth $1.2 million, the taxable gross estate will be worth $1.2 million even if you had a mortgage outstanding that was worth $800,000. By definition, the taxable gross estate does not take into account any debts. So you need to be really mindful when it comes to what the taxable gross estate truly is. So off the bat in probate, it's fairly expensive when you have to take into account what you have to pay the attorney and also the personal representative. So in this hypothetical $1.2 million taxable gross estate, you're looking at a cost of $50,000 in total for those two parties that you have to pay to administer the estate. When it comes to the cost associated with administering the trust, how that cost is defined is confined or contained within the trust document itself. Typically, it'll be a market rate that the trustee is paid per the hour that they're worked. And that's mostly it. If that trustee ends up hiring other professionals like a CPA or an attorney, those people will likely get paid by the trust as well. But how everything is done will be contained within the trust. Once the person who created the trust dies, or there's a triggering event where they're no longer the trustee, a successor trustee steps in to the shoes and takes over. So the trustee has duties and they're bound by the terms of the trust, and they have duties to the beneficiaries. So when it's time for them to administer the trust, if it's simply to divide a portfolio 3 ways between people, it could be done as simply as moving those assets and distributing those assets to those 3 beneficiaries and calling it a day. So when it comes to administration of that, it could be fairly nominal, and then the trustee is simply paid whatever the market rate fee for their time to get it done. And speaking of time, the second major difference between a will and a trust when it comes to working with assets and distributing them is time. So going through probate, because it is a court proceeding and it depends heavily on the caseload, it will actually take a very long time to go through the probate process. Right now in the state of California, on average, you're looking at about 1 to 2 years. And if there are any issues with the probate, or if there are any litigants in the probate, it could take even longer than that. When it comes to using a trust to manage and distribute assets, that could be done within a matter of months or weeks instead of 1 to 2 years. Lastly, the biggest difference between a will and a trust when it comes to managing and distributing assets is privacy. A will through probate is definitely not private at all. Everything that's filed in probate court will be seen by anyone who's motivated enough to look into it. The will is lodged with the court, and anyone and everybody will know exactly who will get what and how much and what issues there are with the administration of the estate. When it comes to a trust, the trust by default stays private. It's a private document. Even when you're interfacing with other entities like banks, the trustee who will be working with the bank typically just gives them a certification of the trust, not the trust document itself. And unless there are issues with the trust, or unless there's litigation involving the trust terms often just stays private between the beneficiaries and the trustee and the original trust maker. So there you have it. That is the main difference between a will and a trust.